Thanks for staying with us, everyone. Let's turn now to Benue State, where the state government says it's not aware of the alleged relocation of the state local government election petitions tribunals to Abuja. Fidelis Meniem, who's the Attorney General and Commissioner for Justice and Public Order, says they woke up with the rumors that the tribunals have been relocated to Abuja. The Attorney General added that neither the governor nor his office received any correspondence notifying them of the decision to relocate the tribunals to Abuja. He said the state government ought to have been informed of the relocation and that reasons for that decision should have also been communicated. But the reasons for the relocation is actually out there. Justice Ekpebese had issued a circular with the title Directive for Immediate Relocation of the Local Government Petitions Tribunals to MBA House, Abuja, explaining that the move was necessary due to security threats and ongoing strike by the Benue State Judiciary Staff Union. And this circular was dated 4th of March 2025 and addressed to all tribunals in Makurdi, Gboko, and Otopo. Joining me now is a lawyer and public affairs analyst, Madaki Michael, for more on this development, especially as it relates to relocation of the Benue State Local Government Election Petitions Tribunals and other matters arising. Thank you for joining us on the program this evening, Mr. Michael.
Thank you very much, Nifemi. Thank you for having me.
So, it sounds very clear. Justice Ekpebese has cited security reasons as the primary concern for relocating the tribunal proceedings to Abuja for the safety of the justices. What do you make of this?
Okay, thank you very much for that question. Nifemi, you see, the procedures and conduct of the tribunal are of such sensitive nature that they are clearly provided for by law. These are not procedures that you wake up and then take your own decision on. They are provided for by law. And in this instance, it is provided for under Section 83 of the Benue State Electoral Law 2007 as amended. And in that provision, Section 1 and Subsection 2, particularly Subsection 2, says the venue for the tribunal can only be changed if all the parties to the petition consent. If all the parties to the petition give consent, that is the only time where the venue of the tribunal can be changed, under Section 83 sub 2. Now, this is not just saying, it has actually come into action. In this very line of petitions that is going on in Benue State, in December of 2024, just about 2 months ago, in the Benue Northeast Local Government Election Petitions Tribunal sitting in Adipo, Ikwandu Local Government of Benue State, the Respondents' Council, Mohammed Ndarani SAN, made an application to the Chief Judge of Benue State, urging that the venue of the tribunal should be shifted from Adipo in Ikwandu Local Government to Makurdi, which is the state capital. The learned SAN Council for Respondents, 93 respondents, then cited the issue of insecurity in Ikwandu Local Government and that there was not a good accommodation suitable to accommodate the retinue of lawyers that were attending the cases in Adipo. Now, when he made this application, he did not put the fact that he has sought consent of all the parties as provided by Section 83 of the Benue State Electoral Law as amended. Now, when the application came to the Chief Judge himself took a close look at this and responded in his own hand and rejected the request. And the reason for his rejection of that request was that the consent of all the parties had not been sought. The Chief Judge went ahead to state that it is difficult to come to terms or agreement with Leonard SAN for his reason for choosing that the venue should be moved to Makurdi, because if he's citing insecurity in Ikwandu Local Government, the court in Adipo, the Benue State High Court, was still sitting. So he doesn't understand why the Benue State High Court is still sitting in Adipo while the Leonard SAN as counsel for the respondents is citing that as the reason for it. That if he needs that to happen, in essence, he must seek consent of all the parties to the petition as provided by law. Now, you have a situation where just maybe a month later, almost the same set of circumstances has happened. Now the Chief Judge is acting unilaterally. As far as what is out there is concerned, there is no consent that has been sought.
Just a minute, Mr. Michael. I hear you. Yes. I hear the precedents, but the Chief Judge is also raising certain critical issues here, including ongoing strike by the Benue State Judiciary Staff Union, who went on strike last year because of non-payment of the renegotiated minimum wage. And he's talking about the need to ensure smooth operations within the mandated legal framework, time frame of this judgment. We've already heard from the PDP. Are you suggesting that the position of the Attorney General and Commissioner for Justice represents the position of the APC in this matter?
Okay, at the moment, the Attorney General and the Commissioner of Justice, he is the leader of the bar in Benue State. So, if there's going to be any such decision of such weighty magnitude, it is only proper that his office should be notified of this kind of decision. But more to the fact that the Chief Judge has gone ahead to issue an order directing that the election petition should be moved to Abuja. That is totally unheard of. If he is citing the issue of insecurity, well, insecurity is of such nature that perhaps people occupying such exalted positions like he does will have more insights in it. But then, why is he relocating it all the way to Abuja? Nifemi, in Benue State, there is the Tactical Air Command of the Nigerian Air Force, there is the Nigerian Army Barracks, 72 Barracks, there is the Special Mechanized Section of Paratroopers in Benue State. Why not move, for security purposes, move the sitting of the tribunal to any of this venue, but within Makurdi, Benue State, just to comply with the same thing that you're talking about, convenience and all of that? It is just difficult to understand, except if there are other authorial motives here
Mr. Michael,
that are not clear.
I hear your questions,
for you to say you move it all the way to Abuja.
I hear your questions, but another valid question is, why is Benue State government resisting movement from Benue to Abuja, which is expected to be a level playing field, if it says it doesn't feel safe and the judges also do not feel safe in Benue State? For instance, as we speak, judiciary workers
so Nifemi,
are on strike.
Let me cut you down there and say that, okay, so are you saying it's judicial workers that are on strike or that people are afraid? For the strike, let me tell you plump and clear. The Election Petitions Tribunal is of a special nature. In law, we say it is sui generis. It is not populated strictly by judicial workers. It is populated by special appointees that are drawn in to sit specifically for that purpose. And because of the nature of the 180 days that is attached to it, it does not conform to the day-to-day laws and regulations that guide the judiciary that are presently on strike in Benue State, which is a story for another day entirely. As we speak, the Federal High Court is sitting in Makurdi, Benue State. The Court of Appeal is sitting in Benue State. How can the tribunal that is populated by Benue people not be able to sit? But more importantly, it is provided in the Constitution of the Federal Republic of Nigeria, 1999 as amended, that the administration of local government is tied to the state government. What that means is everything that has to do with local government has to be tied to the state. You cannot, in fact, it is unprecedented to say in the whole of this Nigeria that anything bordering on local government administration within a state has been taken out of the state. For all the other tribunals that have been taken to Abuja, perhaps for one or two reasons, they have been tribunals set up by the Court of Appeal who are handling issues relating to the Independent National INEC relating to that matter, not issues relating to the state. It is provided clearly in the Constitution. Any attempt to make this kind of move infringes on the very fundamental principle of federalism that puts the federal government away and the state government and the local government. It is unprecedented. As a matter of fact, in the east, just in the southeast, judges were being killed by IPOB and on their order for stay at home on every Monday. Judges were being killed. There's a case in Imo State in Ogwata, why the president of the customary court, while sitting IPOB members came, dragged him out of the court and executed him. Yet,
I hear you. Mr. Michael.
when elections were conducted in that place, so I'm just saying on the issues, on the base of insecurity, there is nothing tenable here.
So
it is clearly provided for by the law.
why do you think,
and with all due respect, my
just
Lord,
a minute, why do you think the Chief Judge is moving these tribunals to Abuja?
Okay, so now these are questions that perhaps he might need to bring forward.
No,
if I were a respondent, if I were, okay, let me answer that in the position of if I was a lawyer.
Except you have a specific reservation, it sounds like a level field playing.
We do. There are indeed specific reservations on the whole of this matter. Look, you cannot discuss all of these things without relating it back to the politics of the matter. Let me just give you a summary of the matter. APC is divided into two in Benue State. There is the one that is more or less regulated, guarded, and administered by the governor of Benue State, His Excellency Reverend Father Hyacinth Alia. And then there is the one that is regulated, managed, and all should do all kinds of things by our father, the SGF, Senator George Akume, together with all the members of the House of Reps and the senators. They call themselves stakeholders in the APC. So we also call them stakeholders. But for the Reverend Father Governor, we call them the masses. So last year, the APC National Working Committee dissolved the standing state ESCO of the APC and installed a caretaker committee led by Chief Omale. Now, when it came for the elections, Chief Omale's interim committee set up by the National Working Committee conducted the primaries, and they fielded candidates across the 23 local governments of the state, who also have over 270 councillors of the various local governments. The election was conducted, and these people won elections that were sworn in October. At the same time, the other party that was dissolved by the ESCO that was dissolved by the National Working Committee also conducted their own primaries. And they also listed 23 local government people as purported candidates for the party, and also over 270 people as councillors. Now, when the elections were conducted and the tribunal was set up, the party led by the stakeholders people, with the over 290 officers that are contested, allegedly won primaries for chairman and councillors, came to court to file petitions. And this is where this thing started. This whole thing, that's where it started. Because at that very moment, there were 295 of them that came to file petitions. They needed to pay costs. Security costs as provided by under Section 76 of the Benue State Electoral Law. The Chief Judge at that very moment, because all chairmen had to pay 500,000 naira as security costs, while councillors had to pay 300,000 naira as security costs. If you calculate that money, it's well over 100 million naira. The Chief Judge on his own issued a waiver, waiving the payment of all of those fees. And that is one of the bases upon which the Benue State House of Assembly took it up with him and passed the motion urging
Mr. Michael, Mr. Michael,
these are mandatory provisions.
We are running out of time now, but I don't want us to get back to the legality of the State House of Assembly.
The whole thing is pointed towards
that. So I don't want us to get back to the legality of the State House of Assembly removing the Chief Judge, because
I'm not going to that.
The NJC and the NBA are very clear about that. But this recent development, if you allow me, Mr. Michael, because we have just about 2 more minutes to go. If you keep talking while I'm talking, we're not going to be able to understand each other, right? So you need to hear the question first so that you can, get my side of the story as well. This is happening aftermath what appears a tension between the Benue State government and the Chief Judge. The governor had petitioned him before the House of Assembly, and they had removed him in controversial matters. Now, what the Chief Judge has said, what he claims to be the reason why the governor wants him out, is that he was removed because he refused to appoint the governor's preferred justices to the local government election petition tribunal. You mentioned earlier that it is unprecedented to have moved it from Benue to Abuja. I'm sure you agree that it's also unprecedented, the kind of allegation he's making. If it is true, you don't think that nothing substantial will happen under the supervision of Mr. Governor if this allegation is true?
Okay, Okay, so I only made mention of that when you said the reason was for security reasons. That is why I brought up that issue. Because if for security reasons, then there are very secure spaces in Benue State that this can happen. And as we speak, court business is still going on. Now, going on to the issue of the type of allegations that the Chief Judge has alleged are the basis of what is happening between him and the governor. I will also use the same Chief Judge's words, his own words. There's a video that he attended an event and spoke clearly where he said his problem with the governor came from the fact that he refused to appoint judges that would favor the governor, but he chose to appoint judges that would be very difficult for the governor. These are the Chief Judge's words, not mine. These are the Chief Judge's words. So if it is putting up the position that the governor approached him to appoint people and he did not appoint, he himself is admitting and is on tape. It's all over the place that he now took the decision to appoint judges that to use the local parliament to pepper the governor. This is where we are. So whatever the issue is, it must be regulated by law. And the law in this instance is the Benue State House of Assembly Electoral Law 2007 as amended. And no matter what decision that has to be taken, on no matter what basis, it has to be fixed back to the law. We cannot use emotions and sentiments and various loyalties that are not defined to push narratives that come in to distort a process of governance and all of that. So for now, all I'm saying, and this is very clear, you can go and confirm, you have your sources, the provisions of the Benue State law, and then the CJ's own decision on this same procedure for moving venue that he gave in December of 2024.
I hear you clearly. Madaki Gwaza Michael is lawyer and public affairs analyst. Thank you so much for joining us on the program this evening.
Thank you, Nifemi, for having me. It's always a pleasure.